My name's Colin Yeo. I'm a practicing barrister. I'm based at Garden Court Chambers in London. I personally live in Bristol. I've been working in immigration asylum law for just over 20 years now. I've seen quite a lot of changes in that time. And I also founded and edit a website that a lot of people use in the immigration sector called Free Movement, which sort of tries to keep people up to date on what's going on. And just before we started this, I was busy reading through the new immigration bill and trying to work out what on earth that means and sort of get on top of that. So yes, nice to take a break from that and move on to this. So I've been asked to talk quickly about essentially what awaits EU citizens now that the deadline for the settled status scheme has passed. And to answer that question, I think, and it's a bit ominous when I say I've identified 5 groups, because it sounds like it's going to take ages to go through that. I hope that's not the case. But essentially, there are sort of 5 groups of EU citizens. So you've got those who have applied for and got settled status. You've got those who've applied for and got pre-settled status. You've got those who have applied and are awaiting a decision, and there's quite a substantial number of them. You've got people who haven't applied, but then do apply. And then I've added a sort of another group as well, which is the people who haven't applied and don't, basically, or at least don't in the near future. And that's always going to be, those 2 groups, those 2 final groups are always going to be an unknown number. And I'll come back to them at the end. Before I sort of get started on that, I thought it'd be just helpful to say at the outset, one of the things to remember with this is that the UK government doesn't really directly control immigration checks within the UK, because we've got this kind of system of there's different terminology you might use: deputized immigration controls, delegated immigration controls, privatized, whatever it is. Essentially what used to be called the hostile environment by Theresa May when she was Home Secretary, and now has been rebranded as the compliant environment. And it's this idea that employers, landlords, NHS staff and others, I was going to say have to check the immigration status of people they come into contact with. That's not quite right, actually. They're not legally obliged to check everybody's status. What happens, though, is that they get fined or into trouble, at least, if they don't check the status of somebody who doesn't have permission to be here. And it kind of builds in this inherent discrimination. So if they encounter somebody who they think probably has lawful status, for example, they may reach that conclusion on the basis of their skin color, their local accent, their name being a traditional sounding British name or something like that, then they might think, well, okay, the chances are they've probably got legal status. I don't need to carry out my checks on them. Whereas if they encounter somebody who doesn't have those qualities, they've got a foreign sounding name as far as that person's concerned, perhaps they've got a darker skin color, whatever it is, something that makes them think, well, actually, this person might not have immigration status. I do need to carry out the checks on this person. Otherwise, I might end up with a £20,000 fine. So it kind of encourages them to carry out checks on some, but doesn't require these checks to be universal. It's not a kind of universal immigration checking system. And one of the problems with it is that they're encouraged to do too much, essentially. They're encouraged to be overzealous, because the way the system is designed, they're punished if they don't do enough, but they don't get punished if they do too much. And so when you hear the government saying, well, we're trying to be lenient, and we've told our guys to be lenient, the benefits officials and so on, that's all very well. And they may have put out some nice guidance for landlords or employers to read online. But the reality is that landlords and a lot of employers, they're not going to be reading that stuff. They don't really understand how this works. They just don't want to take risks. They do not want to get a £20,000 fine in the case of employers, 5,000 in the case of a landlord. And so they often act over cautiously and may well deny services to people, even if those people are entitled to that service, whether it's a job or rented accommodation or something like that. So there's just something, it's the kind of context to what's going on, and this rather kind of odd semi-ID card system that we have. It's like a kind of non-universal ID card system. It's really quite strange, actually, I think, from a legal point of view. So let's get back to the actual groups. People who've got settled status, what have they got to watch out for? Well, the first is that they don't have any proof of their status. They don't have any documentary proof. And that means that a landlord or employer or whoever has to contact the government, central government, and conduct an immigration check for them. And if you're a landlord and you've got two people who come to you who want to rent a flat, and one of them is a British citizen who sounds local and so on, and perhaps also has a passport, a British passport, then that landlord can accept that passport as proof of ID, and that's fine. And it's kind of paper proof. But if the other person is an EU citizen who has settled status, they have to get the landlord to basically phone the government or do one of these online checks. Now, they're fairly straightforward, but it's still an extra step for that landlord to take over and above just looking at a passport. So we think that that's likely to lead to some suppliers of services basically discriminating against EU citizens. It seems likely that that's going to happen. Another thing for them to watch out for is criminal offending. Now, this is going to be a very difficult one to talk about in future because some people are going to commit offences and they're going to face deportation. And that's because the UK rules on deportation will apply to future conduct, and the UK rules on deportation are pretty harsh, basically. Anything over 12, any sentence over 12 months triggers deportation. And it's very difficult to resist once it's been triggered. There are human rights appeals and so on, but they're difficult to win. And I can tell you that because I argue them in court on a regular basis. And there are going to be plenty of kids of EU citizens and so on in future who end up in trouble with the law and face deportation, even though perhaps they were born here, but they never acquired British citizenship, or they've been brought up here. They don't know the country that they're facing deportation to, and that's not going to help them. They're going to be deported. And there's going to be a trickle of those cases over the next few years. The next group are those who've got pre-settled status. So they've got two big things, I think, to watch out for. The first is that they've got to make sure that they do apply at the end of their pre-settled status. And if you introduce any kind of process where there's an essential step for people to take, some people are going to drop out, basically, and some people will forget to apply at the end of the 5 years. And if they do, they become unlawfully resident. And that they're not helped by the fact that they don't have proof of their status in a passport. So if you've got a passport and you've got a stamp in it, and you can see it and you can read it, or you've got a vignette, one of those sort of modern vignettes in your passport, it's a reminder of when your leave expires and that you need to apply and so on. Certainly I find that helpful in my actual passport, knowing when I've got to renew it and so on. I look at that to see when the next thing is. Now, theoretically, they've got a letter and they've been told when it is that they're supposed to apply, but it's not quite the same as having it in your actual passports and so on. And so we expect a certain number of those people to simply forget basically to apply when it comes to the end of the 5 years, which then makes them unlawfully resident at that point. There's another problem as well, which has been quite a difficult one for me to sort of try and explain. I've tried to get journalists to write this up, but it's difficult because there aren't any cases at the moment. And that's where people spend a certain amount of time outside the UK. Now, I think a lot of people know that if they spend 2 years outside the UK, then they lose their status and they won't be able to get back in, basically. And I think that's probably fairly broadly understood, although probably there are a group of people who don't understand it as well. Of course, if they've been outside the UK for 2 years, arguably they don't have that close a connection and so on, so it's not that much of a hard case. But there will be a lot of hard cases where people are outside the UK for either 6 months or 12 months, depending on the circumstances, and they're readmitted, they're allowed to come back in. They don't lose their status in the meantime, but what they have lost without knowing it and without anybody telling them is they've lost the right to apply for settled status at the end of 5 years because they're no longer going to be eligible for settled status. So especially with the pandemic, and the Home Office has said, look, during the pandemic, the rule is 12 months, even though normally the rule is 6 months. During the pandemic, that's been extended a bit. So some people will benefit from that. But there'll be quite a lot of people who, for all sorts of different reasons, will stay outside the UK for over 12 months, and then they'll be able to come back in again, but then they'll find at the end of the 5 years that they can't apply for settled status, and either they have to leave the country or they become illegal. And that's going to happen to a big chunk of people. I don't know how many, but that's going to be a big problem in about 5 years' time. The third group are those who are awaiting a decision. And this one's, I think, a bit complicated. I've been looking fairly closely at the withdrawal agreement on this, and there are different kind of, there are different interpretations. Particularly, well, it's more on the late application, actually, that there's different interpretations. But if you've already made an application and you're just waiting for a decision after the deadline, then your rights in theory should be protected as long as you ultimately win, as long as you do actually get granted status later. And in the meantime, you should be okay, although you've got the same problem as those who've actually got status, which is you don't have any written proof of it as such. What I find I'm really annoyed by this is that the Home Office has been sitting on a lot of these applications. Essentially, there's a big backlog. Some of the people have applied very late, and so it's not surprising that they haven't got a decision yet. But there's tens of thousands of people, in fact, who've made applications in good time, but the Home Office haven't made a decision in good time, and they've been waiting for months, and they're going to get a decision after the deadline. And if it's a refusal, then they're going to find that overnight they become illegal, essentially. They become unlawfully resident. Now, they will have appeal rights and so on, but they are slightly complicated. I know that. I'm a lawyer. That we're not easy to use as a profession. And also there might be some people who could just have reapplied and been eligible if they'd been refused in time before the deadline expired and so on. So there's a group of people there who, most of them probably be fine because they've made late applications and they'll be eligible, and that's all going to be okay. But there's also a group of people who've made applications sometimes in quite good time, actually, months before the deadline, who are going to be refused and then find themselves essentially unlawfully resident with very, very little notice. The next group are those who make a late application. So they've not made an application before the deadline. Now, the withdrawal agreements on this can be read two ways. On one reading, their rights are protected as soon as an application is made. On the other, they're only protected once a decision has been made on their application. So if it's the latter, then they could face months of uncertainty because there's a huge backlog that the Home Office has still got to work through. No doubt they'll be working through that first before they get onto the late applications. And those people are going to have no proof of status and indeed no status while they're waiting. And as I said at the beginning, I sort of prefaced this at the beginning, if you are a landlord or an employer and you come across somebody in this situation, then I think actually the way the Home Office guidance is designed is they're supposed to allow these people to stay, and they're supposed to let them have the job or rent to them and so on. But because the landlord or the employer or whoever is going to be thinking, well, I'm not really all that sure about this, they're encouraged not to, essentially, by the system design, the way that the hostile environment works. So the Home Office guidance looks fairly generous, but that's not necessarily how it's actually going to be applied in practice by non-Home Office staff, who are the people who are actually applying these immigration checks in real life within the UK. There's also the extra hurdle, which is that they have to show there's a reasonable excuse for their late application. And again, the Home Office guidance on this is fairly generous, but there could be loads of people who haven't applied and who don't have what the Home Office considers to be a reasonable excuse. People who were scared of applying, I don't think there's any allowance for them. And there's going to be quite a few people in that situation, sadly. People who mistakenly thought they didn't need to apply or thought that they weren't eligible to apply, but then later realized that they are. People who didn't even know about the scheme, which seems inconceivable to people who are following all this and read the news and so on. But there are loads of EU citizens who just don't know about this scheme, bizarrely. Sometimes that's for language reasons and so on. And some allowance is made for them if they do have special reasons like that. But if they simply just don't read the news and they don't know about it, there's no allowance made for them in the guidance, and they'll be excluded. And basically, they can't then make an application, and they're going to have to leave the United Kingdom. And then you've got, sort of related to that, the last group, the people who just don't make a late application. And there are likely to be a lot of people in this situation, but it's impossible to judge how many. Could be tens of thousands. It's a small percentage, but of a very large number, probably. And essentially, the unlawfully resident population of the UK went up by a substantial but unknown number on the 1st of July. And the effects of that are going to be hidden for months and years. There's not going to be any Armageddon or apocalypse sort of that becomes immediately evident. It's going to be a kind of drip, drip, drip effect over the coming months and years. And it's going to cause really acute difficulties for those who are affected when they finally realize that they've got a problem, potentially years down the line, especially if they're children now. So I'm going to finish there. That's and what they've got to watch out for, bearing in mind that the Home Office might make the right noises about being generous, but they're not necessarily able to actually implement that on the ground because they don't fully control the system that they've created.